So this is the fourth session, if I'm not mistaken. And the first speaker, the first intervener is, I should give the floor to Nikola Cvetković from the University of Belgrade Faculty of Law. And the title of his intervention is The Reception of European Laws in Meiji Japan, 1868 to 1912.
Okay.
Nikola, you have the floor.
Thank you very much. Thank you very much. Ladies and gentlemen of the public, esteemed professors, scholars, and others, it is an honor to be here today in order to present to you my paper on the topic of the reception of European laws in Meiji period Japan. So let us begin. Before we speak of the process of reception itself, I'd like for us to take a look on some key historical events, among many others, which have influenced and led to the occurrence of legal reception and modernization in Japan. I now ask of you to take a look on the screen. Hopefully you can see a map which depicts the Far East in the 19th century. As you can see, the Far East was filled with numerous colonies, for example, French Indochina, Burma, owned by the British, as well as declining, dare I say, semi-independent empires and kingdoms of old, such as Siam, China, Japan. You may ask, why declining, why semi-independent? Well, the 19th century proved disastrous for these old nations, as a new formalized concept of relations between the European great powers and the Asian empires of old was invented. This concept was the signing of the so-called unequal treaties. These treaties were bilateral agreements, mostly peace treaties between an Asian nation and an European great power, which contained one-sided norms through which the European great powers secured for themselves huge benefits, mostly in trade, with no regard for the sovereignty of the Asian empires. The first unequal treaty signed was the Treaty of Nanking, the peace treaty which ended the so-called First Opium War between Qing China and the United Kingdom. This treaty humiliated China, and Britain secured for herself enormous benefits. China thus suffered an economic and political humiliation and downfall. When the news of the Opium War soon reached Japan, it prompted a certain Japanese writer to say the following, and I quote, "How can we know whether the mist gathering over China might not come down as frost in Japan?" The mist eventually came down as frost in Japan, but the frost wasn't British, rather it was American. The Americans were interested in becoming a commercial power in the Pacific, and they wished to increase trade with Japan. Open new whaling stocks, protect American sailors which were subject to harsh treatment by Japanese authorities, and acquire coaling stations in the Western Pacific in order to supply their growing steam fleet. The Americans were successful in their mission of opening Japan, and with the help of good old-fashioned threat of force, Commodore Matthew Perry persuaded the Japanese to sign the Convention of Kanagawa in 1854, which effectively ended Japan's 215-year-old policy of national seclusion known as Sakoku, administered by the Tokugawa shogunate. The convention led to the opening of the ports of Shimoda and Hakodate to American ships, provided for the repatriation of shipwrecked sailors, established American consulates at the newly opened ports, and etc. Soon, other Western nations, such as Britain and Russia, signed similar treaties with Japan. In 1858, the Americans signed another unequal treaty with Japan, the Harris Treaty, which opened the ports of Kanagawa and 4 other cities to trade, and granted extraterritoriality to foreigners among a number of trading stipulations. Through these treaties, Japan's relationship with the European and an American great power was similar to China's after Nanking. The signing of the Harris Treaty led to enormous amounts of dissatisfaction in Japan, and it led to anti-foreign sentiment across the nation. The Emperor Osahito, the Komei Emperor, took a resolute stand against the treaty, and was seen by anti-foreign and anti-Tokugawa imperial royalist elements as a rallying point in the fight against the Tokugawas, who failed to uphold the ancestral law of Sakoku and allowed the foreigners to enter and defile their lands. Foreign traders at that moment controlled 90% of Japan's trade with the outside world. The rebellion against the Tokugawas was at first violent, as rebellious daimyos conducted terroristic operations against the Tokugawas, and later against the European and American presence in Japan. During this 10-year insurgency, the first men were sent by both the Tokugawas and the imperialists to Europe to bring home Western knowledge and weapons, and the first ideas of the need for Japanese modernization emerged. Civil war erupted in January of 1868 with the goal of reenacting the new Emperor Mutsuhito's direct imperial rule, but this civil war was surprisingly relatively bloodless. The last Tokugawa shogun peacefully surrendered Edo, modern-day Tokyo, to the emperor and resigned from his position of shogun. This led to the historical event known as the Meiji Restoration, which also marked the beginning of a new period of Japanese history, the period of enlightened rule. The restoration of the emperor's imperial rule was only a way to justify the rebel cause. It was soon clear that this conservative goal masked a fundamental urge to reshape the country from top to bottom, transforming it into a modern nation. Now we can move on to the consequence of the aforementioned historical events, the transformation and modernization of Japan, and thus the legal reception that took place. With the success of the Meiji Restoration, the new Japanese administration sought to strengthen Japan by adopting Western institutions and mastering Western technology in order to compete with the countries who imposed the unlegal treaties on Japan. The reform of the law was seen as an urgent necessity, as the Meiji government also wanted to obtain the revision of these unequal treaties, and the great powers demanded the modernization of the Japanese legal system as a condition to any revision taking place. The Japanese government did not have the time to allow the law to be created spontaneously according to the needs arising from the state of the Japanese society, so the pressure was there to actually concentrate on providing a new legal system, whatever the social state of Japan might be. The goals of the new regime were outlined in a document known as the Charter Oath, which was promulgated on April 6 of 1868. This oath consists of 5 clauses, which demonstrated a plan for further modernization. However, for our topic, a peculiar clause is the 5th one, which states the following: knowledge shall be sought throughout the world as to strengthen the foundation of imperial rule. We could treat this clause as a sort of a motto, a sentence which refers to the method which the new Japanese government implemented in order to modernize the state and the law. This method mostly consisted of sending missions of Japanese officials to the West in order to gain knowledge which would then be adapted and adopted in Japan. And the second method was to invite foreign experts, such as Boissonnet, who will be mentioned later, to come to Japan and aid in its legal evolution. One such mission was sent to the Western powers in order to renegotiate the unequal treaties, and the Japanese spent a year and a half traveling across the US and Europe, and they visited enormous amounts of factories, arsenals, government ministries, military academies, etc. And they were surprised by the diversity of the West. But they were mostly fascinated by the newly established German Empire, which was a nation, according to them, as it was also formed by the unification of a large amount of small principalities. Thus, in the end, Japan found the countries from which it would take the inspiration in order to reform and compete on the global scene, and to signal to the world that it is now a modern nation state. Since my paper focuses on 2 legal problems among many of this process of reception in Japan, the Meiji Constitution of 1889 and the Japanese Civil Code of 1896-1898, I've decided to analyze only the Japanese Civil Code for the purpose of this presentation. To be specific, we'll see how the ideas of reception, how it should be implemented, changed, evolved as time passed by during the writing of the Civil Code. So, thus I tried to divide the timeline into three key phases of reception. The first one, I dubbed the Napoleonic phase. During this time, Japan chose the French legal system as its guide, since the common law appeared too complicated, while France had the 5 Napoleonic codes. The government was so impressed with the translation of the Code Penal, the French criminal code, that in fact it had hastily decided that the French Civil Code should be translated as well and directly applied as Japanese law without any amendments. These translations were the first step to the final product of full reception of European and Western law. And even though the Japanese wanted to apply the Code Civil in a translated form, they didn't give up. They realized that having an original Japanese Civil Code was important. And a committee was set up for this purpose, tasked with writing a new Japanese Civil Code, which was based on the French one. In 1878, a draft Civil Code was in 3 books was completed, but it was not adopted because of its too faithful imitation of the French Code. Therefore, the government decided to call in French experts to help. Thus begins the second Boissonnet phase, named after Gustave Boissonnet, who was a professor at the faculties of law in Paris and Grenoble. And in 1873, he was invited by the Japanese government to take on the task of improving the legal system, and he stayed in Japan for 20 years at the wish of the Japanese. After finishing some work with the procedural code of Japan, in 1879, he proceeded with the task of drafting a civil code. He took part in writing the section concerning property law, while the family and succession law were left to Japanese lawmakers who would regulate these areas in accordance with Japanese societal ideas. Boissonnet based his draft on the French Civil Code, but he used a comparative method in his writing of the draft. He worked tirelessly, studying the legislative, judicial, and doctrinal developments in other countries. And he said the following: "Doubtless what Japan adopts should not be French law purely and simply. I want your government to adopt our laws only to the extent that they have been proved good by the experience of 3/4 of a century. I will use every effort to incorporate in the draft the improvements that time has shown necessary, and particularly those improvements that other Western jurisdictions have adopted in their wisdom and justified by their experience." In conclusion, Boissonnet's method meant that the Japanese Civil Code should be written according to him by implementing not only French solutions, but also solutions of other nations in accordance with the success of such solutions in practice. The code was not just a copy of the French codes, but it followed a form very similar to its original state, and even though it was composed of 5 books instead of 3. However, it didn't come into force as envisioned, because from 1889 there were indications of a movement which was hostile to the future application of the code. This movement did not sufficiently take account the morality of Japanese people. They were of the opinion that Boissonnet didn't appropriately regulate the law in accordance with these traditions, and this reasoning didn't have its justification, to be honest. However, there was a more important reason, a political one, why the Boissonnet draft failed. In 1889, French influence waned in Japan. That same year, the Meiji Constitution was proclaimed, which was written under the influence of German professors such as Ressler and Mosse, and which took an inspiration the Prussian Constitution of 1850. Japan started to look up more to Germany, whose absolutist and monarchistical tendencies were deemed as an adequate model for Japanese legal reform. Thus, with the rise of German influence in Japan, begins the final Germanic phase of legal reception, and the new commission was formally charged with the revision of the Boissonnet Code. Many foreign systems were consulted in this work, but particular reference was made to the two drafts of the German Civil Code, the Bundesgesetzbuch, and the commission had decided to give up the scheme of the French Civil Code and substitute it with that of the Bundesgesetzbuch. The code was promulgated, the first 3 books, in 1896, while the other 2 books on family law and succession were drawn up with great caution because of the potential criticism for not writing these parts in accordance with traditional Japanese morality. These books were finished in 1898, and the complete civil code came into force on July the 16th of 1898. In conclusion, we will finish this presentation with the following. How much did this final code differ from the Boissonnet draft? Well, those who had favored the postponement of the Boissonnet draft wanted to believe that it differed substantially, and looking at form alone, it could indeed be thought to be entirely different, for the method followed in its construction was German. But when we consider the content, the story is different. Many of the solutions given in the drafts of the German Civil Code were adopted, but they also retained many of the provisions drafted by Boissonnet. What is more unusual, they sometimes accepted solutions other than those found in either the German or the Boissonnet draft. And the new code was sort of a melting pot. So, in conclusion, the new code is based on the French code and other codes of French origin as much as it is on the German code. This would be all the key points of my paper which would fit in this time frame. So I thank you all. I'm open to any questions or comments afterwards. Thanks.
Thank you. And thank you for respecting the time frame. Now the floor is yours. Comments, questions? Okay.
Take the questions to
Thank you very much for this story about the implementation of MIMPO in Japan. MIMPO, the name of the Japanese Civil Code. Yeah, it is really fascinating. Actually, I've been to Yokohama, and that's the very harbor when everything started, and you can still visit in the former British consulate. But most of the pictures you showed in your PowerPoint, I mean, they are in this exhibition. What is also very funny in this exhibition is that they put numerous paintings of the face of Commodore Perry. You showed something that looks like human, but the Japanese obviously did not see him very much, so they painted him in very strange ways. I mean, you would never recognize him, and it's quite funny. But that's just, again, just the consequence of being separated from the whole world for so long. You know that the only foreign goods in Japan were Chinese and the Dutch, and that you would never imagine why the Dutch. And actually, they were not allowed in. They were allowed to artificial island in the harbor of Nagasaki where they would exchange things. But what I found out also in Osaka is that actually they have a very old building where you can read, find what the Dutch navigators brought to Japan, and you have actually grammars so that the Japanese could learn Dutch to be able to read scientific books and to learn from it. So it's really, really funny to see that. This period is fascinating. To my knowledge, yeah, what my Japanese colleagues say about MIMPO is that many articles are still written like Boissonnet imagined them in French law. Whereas, of course, the structure of MIMPO is in 5 books, just as the BGB. By the way, BGB is not Bundesgesetzbuch, but Bürgerliches Gesetzbuch. Yeah.
I'm sorry for this.
It was no federation by the time. It was, and Bürgerlich means civil, so it's indispensable.
It was an honest mistake.
Don't worry, but I thought that it might be corrected on this, and I don't know whether I spoke a lot, so.
I really thank you for the comment, because I did plan on adding that subtopic of first Japanese contact with Europeans, because that is also a key factor in the reception, the contact with the Portuguese and the Dutch in Nagasaki. And when you look at Sakoku, the whole point of that policy was to protect Japan from European influence, to protect Japan from Christian influence, because there was a lot of Jesuit missions in Japan, and the Japanese were so intimidated by the possibility of Christianity becoming the state religion in Japan that they decided no more contact with the West. So that's also a key point.
Yeah, they have been very influential, but Japanese killed a lot of Jesuits. I mean, you can see the bones in Macau still, and at the St. John's Cathedral, of what is left of it. I mean, you still have that pilgrim place for Portuguese Jesuits. It's also an impressive place. But they were allowed to remove them from Japan, that's true.
More questions, comments?
So just while we're not doing anything about the Japanese Commission, sorry for that, taking your time, but the Japanese Commission is quite interesting. The three Japanese authors, they all studied in Europe. One of them in Lyon with the famous Romanist Charles Appleton, or Appleton, because it was of English origin, but became French. And it's actually interesting. One other studied in Germany, I believe. And so this is how they also had a very good knowledge in the end of French and German law to write down then the final WIMPO.
It was very peculiar, and I read that in literature, that all of those members of the committee were actually trained in other laws other than German, in British and French law, but they all thought, no, the German law is better, and they decided that maybe Germany is the best source.
Yeah, well, that was a general opinion in those years. I mean, and also that was the most recent code in the making because it wasn't finished. But it is true that most German historical school, because they thought, well, this is actually the best you can find on the market now. And the French did that too, by the way, with Raymond Saleh writing a book on Théorie générale des obligations, the project, the first project of the BGB. And that really changed the law of obligations in Belgium and in France. And that's also an interesting effect, even before that the BGB came into force, it had already some influence on French law through separatists, of course.
Just want to ask about the influence of Bogišić. Also, this is something that maybe you can say a few words about that. My question.
Yeah, well, I also found that Baltazar Bogišić, who was the author behind the, how can we translate Opšti imovinski zakonik to English? Yeah, General Property Code, that actually he had contact not with Japanese, but with Boissonnet himself in Paris during a certain convention, a legal convention. And here he found out about Montenegro, about those processes of legal that were happening in Montenegro in the 70s. And when you analyze the Japanese civil code, you can also find some similarities between Bogišić's final product in 1888 and the Japanese civil code. For example, this method of regulation of family law and succession law, in particular, Boissonnet was inspired by Bogišić's rhetoric that in Montenegro, these subjects of law must be defined in accordance with the customs of the Montenegrin tribes. And it is really fascinating when you analyze the Japanese and Montenegrin society that they have a similar view of life and of tradition, of society. And maybe that's why the Montenegrin solution actually succeeded in Japan because of a similar point of view.
And the hereditary law were out of the code. They were not codified in Montenegro.
Yeah, but the whole point was that they didn't. The writing of the Japanese civil code happened before implementation of the general property code, and the inspiration was only in verbal talks and not in the norms itself. But when you compare, at least I didn't really touch on that subtopic as much, but when you compare the style of the writing of both codes, you see some similarities in the method of regulation. That's the point of, at least that's how I understood. I'm hoping that I'm correct in this assessment.
So I'll give the floor to, I don't know, Julia Zygała from the University of Warsaw, Faculty of Law and Administration. And the title of her presentation is Alan Watson's Theory of Legal Transplants and the Transfer of Property in the Civil Code of 1898. Julia, you have the floor, finally.
Thank you. My name is Julia Zygała. I'm from University of Warsaw. And my presentation is about the topic of transfer of property in the Japanese Civil Code of 1898 in the light of Alan Watson's theory of legal transplants. The Japanese Civil Code of 1898 had been called by one of its authors the fruit of comparative jurisprudence. And in my opinion, this expression is not an overstatement, given the fact that during the drafting of the initial version of this codification, the legal orders of more than 30 countries were referred to. There is no doubt that the process of creating this codification of private law was a point of interweaving of solutions from different legal orders and even legal traditions. In particular, French and German regimes, which competed with each other during the codification of law in Japan, were of great significance. A good illustration of the necessity to choose one of these legal orders is the issue of the transfer of ownership model for Japanese law. Next slide, please. The main thesis of this paper is that Alan Watson's criteria of authority and availability are not always sufficient to determine the mechanism for selecting foreign law as the donor system. Firstly, I will draw the comparison between the French and German model of the transfer of ownership. Secondly, I will discuss the criteria indicated by Alan Watson as relevant to the choice of foreign law to be transplanted and the adequacy of this criteria regarding the case of Japanese Civil Code. Then I will once again briefly summarize the history of the codification of the Japanese civil law. And finally, the topic of the transfer of property in the Japanese Civil Code will be addressed. Let's start with taking a look at provisions regarding transfer of ownership in Napoleonic Code and in BGB. The Napoleonic Code states only one requirement for the transfer of ownership, and it is the consent of contracting parties. In BGB, it is more complex. The transfer of ownership is ruled by two principles: the principle of separation, in German Trennungsprinzip, and principle of abstraction, Abstraktionsprinzip, that are connected to one another. According to the first one, legal acts creating an obligation and legal acts on transfer of ownership, so the disposition, are separate. As it can be seen, the German Civil Code requires not only the consent of contracting parties, but also the delivery. Moreover, due to the principle of abstraction, the ineffectiveness of legal act creating an obligation does not affect the effectiveness of the dispositive act. Therefore, if the sales contract is successfully challenged by the seller, for example, because of an error in the declaration of intent, it will not affect the ownership. Next slide, please. Now I will remind the key aspects of Alan Watson's theory of legal transplants that were already an important topic of yesterday's keynote lecture. So according to Alan Watson's theory, two aspects are essential when choosing this law which law to borrow: the authority of the donor system and the availability of its law. Alan Watson gave the following instances of meeting the accessibility criterion. The considered law is in writing in a form that makes it relatively easy to find and understand, and also readily available. After centuries of isolationist policy, Japan was faced with the challenge of opening of its borders, forced by the Americans in 1854. Therefore, the creation of the civil law system designed for more complex transactions was necessary. Hence, the question arose which legal system should be transplanted. Next slide, please. Now I will move on to the application of criteria proposed by Alan Watson in case of Japan. There seems to be no question that both France and Germany were regarded as authorities in Japan, as evidenced by the establishment of the French law school in Tokyo as early as 1870, and later also the German law school. Professors from both of these countries were invited to Japan by the Japanese government. Moreover, the unification of Germany made a huge impression on Japanese politicians, and Japan's new constitution was modeled on the Prussian model. As for the accessibility criterion, both the Napoleonic Code and the Bürgerliches Gesetzbuch were in writing, which gave them an advantage over English common laws, schools of which had also been operating in Japan since the 1870s. There was also need for both codifications to be translated into Japanese, which was not an easy task due to the previous lack of equivalence of many terms in Japanese, like, for an example, claim. This leads to the conclusion that Watson's two main criteria for the donor system are equally met by both the French and German codes, and the question may therefore be raised as to what factors determine the choice of a specific foreign law in such a case. Next slide, please. Now I would like to tell more about the process of the codification of the Japanese civil law. So after the first and the second draft of the code had been rejected as mere translations of the Napoleonic Code in 1878, the French professor Gustave Boissenard was appointed advisor to the Ministry of Justice in 1879 to work on a third draft. This version was also strongly oriented on French law, and it should be noted that for this reason, the Abstractionsprincip was not introduced, but the French solution of the acquisition of the property only with the pure contract. After all, the Boissenard's proposal did not gain much acceptance, and it was decided to make some changes to it. Next slide, please. Professors Nobushige Hozumi, Masakira Tomi, and Kenjiro Ume, who had all studied in Europe, were chosen to revise the civil code until the 16th of July, 1898, when the code was intended to come into force. This time, works were strongly oriented on the German BGB. It is worth noting that the provisions on property rights remained unchanged, even though the introduction of the German Abstraktionsprinzip was under consideration. However, it was rejected by the editors as too complicated in favor of the French unitary system. So I have to agree with my colleague that many provisions proposed by Boissenard in fact remain unchanged. As it can be seen, the Article 176 of the Japanese Civil Code is quite similar to the provision of the Napoleonic Code I presented earlier, and it definitely doesn't resemble the provision of BGB. Nevertheless, the literal wording of Article 176 of the Japanese Civil Code has not stopped the strong influence of German legal scholarship in Japan called Theorienrezeption. Leading Japanese scholars influenced by German law started to interpret the manifestation of the party's intent in Article 176 of the Japanese Civil Code as the contract transferring title, and argued that this contract should be understood to be different from a contract of sale, which should merely create an obligation to transfer title. That is how Japanese scholars tried to introduce the German Abstraktionsprinzip into Japanese law. The influence of Theorienrezeption waned after the World War I, when the Japanese jurisprudence had come to have a strong interest in sociological jurisprudence, and came to an end after World War II. when the interest of Japanese jurisprudence shifted to other jurisdictions, including in particular United States and France. The prevailing opinion in Japan today considers that the transfer of property takes place through the manifestation of intention of the parties, just like in the Napoleonic Code. The example of transfer of ownership in Japanese civil code shows that Watson's two basic criteria are not always sufficient to determine the mechanism for selecting foreign law as the donor system. The intuitiveness of the solution in question, the ease of assimilation, and in how many countries it is already in force also turn out to be of significance. The latter factor was also noted by Watson some years after the first publication of legal transplants and called habit and fashion. This thesis is supported by the fact that the abstractions principle has been received to this day in far fewer jurisdictions than the French solution. However, there is no doubt that Alan Watson has laid a solid foundation for today's comparative law, and his theory of legal transplants remained a valuable starting point also for today's research and reflection on legal transplants. Thank you for your attention.
Thank you, Julia, and sorry for the trouble that we had with the technique. Now I'll give the floor to those who want to comment and pose questions. Professor Gerkens.
Thank you very much for this presentation. I actually love Japanese law, even though I'm not able to read Japanese. Kanji is too difficult. But yeah, I have the articles 176 and following on my screen, and well, it's exactly like you said anyway. But like I said in my presentation yesterday, it appears that very recently, like last year or the year before that, 22, the Japanese law has changed, not on the transfer of ownership, which remains French, but on transfer of risk. So I confess I'm still not able to understand it because the wording, even in Japanese translated into English, is not easy to understand. This is really a problem with comparative law, is that you are very easily lost in translation. You are confronted with some very imperfect mutual understanding when it comes to analyzing and speaking about technical issues in private law. But I mean, that makes it even more interesting in the end. It's just a matter of insisting until you understand. But thank you very much for your presentation. That was just a comment.
Yes, I completely agree with you that there's always a huge risk when it comes to translation. And that's also what Alan Watson said in Legal Transplants in the chapter about the perils of the comparative method. And yes, there's always this huge risk, but anyway, it's still interesting for the Europeans to try to understand how the European solutions function in different countries and traditions. And thank you very much for the information about the change about transfer of risk. I didn't know that, so thank you very much.
Professor Popović, did you want to take the floor?
Yes, yeah, we've heard really a lot today about this Japanese law, and I only had that idea that this year international conference of ancient historians took place in Osaka. So it's also an interesting fact. It will take place. Sorry? It will take place. It will take, yes. This is what I want to say. And well, speaking about Alan Watson's theory, you mentioned authority and availability. And I think here we should also add a culture of lawyers. He also insists on that point as well. And Alan Watson also says that transplant functions, even if it is totally misunderstood in the society which accept that rule. And we also heard something about that, how it is adopted later on when it is taken from one culture to another, from a donor to the one who accept this rule. This is only one short comment about that lecture, and thank you. It was really nice and clear.
Thank you. More comments, questions? Yes, Mr. Cvetković.
Thank you. Just a short comment. I just wanted to express my happiness that we've touched on Japanese law this session so much, and I really want to thank my colleague from Poland for also talking about Japan in her subtopic, because I'm of the opinion that Japan's legal story is so fascinating, and we ought to discuss more about it, because it's so special, this process of creating a specific legal system which looks like European but isn't European. And once again, I want to thank Julia for also accompanying me in discussing Japan this year. Thanks.
Yes, also, thank you very much for touching this topic. I also find it interesting because in some literature in Poland, you can still find the information that the Japanese civil code was just the simple reception of the Bürgerliches Gesetzbuch, and that's not true. So it was very interesting for me to discover the civil code of Japan as this fruit of comparative jurisprudence. Thank you once again.
I think it's similar also to the Serbian civil code, that first there were like critiques that it was only a blatant copy of the Austrian civil code. But when you go more into the subject, you can see that Hadžić really was original in his way of transplanting Austrian law and making it more Serbian. So we have more examples of this phenomenon. Yeah. So it really is interesting to see that there are a lot of phenomena similar to what happened in Japan, across Europe, across the world.
What is it that Hadžić made more Serbian? The hereditary law, which was completely backward.
Unfortunately, yes. Well, that's what Hadžić. He didn't want that. He wanted to make it equal. It was the state council who insisted. Yes.
And Zadruga, of course, it is very Serbian. Well, not only Serbian, but it is not. You can find it in other civil codes, so it is kind of original institution, yes. Although it made a lot of problems.
Julia, I'm sorry, we have changed the subject. Now we are talking about Serbian law. Do you have something to declare?
No, I think I'm finished.
Well, thank you then, and we'll proceed further on. Our next intervener is Natalia Nieróbca from the University of Warsaw Faculty of Law and Administration, and the title of her presentation is Historical and Comparative Sources of the Model of Due Care in Polish Civil and Medical Law. Natalia, you have the floor.
Hello. First of all, I would like to thank you for having me here. And my today's topic, as you can see, is about the legal transplants regarding the model of Duker in Polish civil and medical law. And at first, I would like to give you a short preview of what I will be talking about. At first, I will give a short preview about the general concept of Duker, and then I will go to historical and comparative sources of provisions in this regard in German and Swiss codifications. Then I will go to the rules about the Duker in a former Polish code on obligations where these similarities are more visible. Then I will go to the current Polish law to compare the models. And lastly, I will talk about the influence such model has on medical cases in Poland. At first, maybe I will remind some basic facts about the general concept and function that Duker plays in civil law. On the most general level, it helps to determine if the conduct of the legal entity should have the effects specified in the law. And the effect linked to the prime function of Duker is the possibility to attribute liability for damages in both tort and contractual regime. Of course, where the principle of liability is fault. And there are also different, there can also be different effects. For example, like limitation of claims or ineffectiveness of the legal act. Okay, so that was the introduction. And going to the main historical sources, which regarding the model of Duker in Poland are German and Swiss codifications. First, I will talk about BGB, and then I will go to Swiss code. During the work on BGB, there were 3 proposals for regulating Duker, and the first one was it tried to introduce the model based the figurative model. Based on the figure of a careful father of the family. Such figurative model is typical, for example, to French regulations. However, during this discussion around BGB's provisions, it was eventually rejected as, first of all, it was come to be foreign to German legal culture. Then because it's in a way, the wording suggested that the entity should focus only on his own particular interests. And then because of the patriarchal overtones that were inclined with it. The second and third proposals were depersonalized, based on the personalized model, and this version eventually prevailed. And as we can see, Article 276 of BGB goes. In the absence of any other provision, the adapter shall be liable for intentional conduct and for negligence. And what's the most important here is the second paragraph. So the definition of what negligent act is. And it is the one that fails to exercise the care required in the everyday life. It is based on the third proposal. The second one was referring to the ordinary care, but it was claimed to be too low of standards. And what's important for the Polish regulations nowadays, this standard was introduced among the general rules on a compensation for damage caused by non-performers or improper performance of an obligation. Okay, going to the switch sources. Here the similarities are less obvious, especially in current Polish civil code. We have the Article 41 of Swiss Code of Obligations, who unlawfully, intentionally, or through negligence, again, causes damage to another shall be liable to compensate for it. We have also a similar provision in contract regime. However, neither of these provisions introduce a definition of what negligence is. And this general standard is eventually precise in Swiss case law and literature, and it refers to the German provisions in this regard. However, it's not what's the most important here for Polish codification. It's the plurality of standards of due in the code. As apart from this general standard, specific provision with respect to different spheres of conduct appear in this code, and I will be talking about it later. Okay, so going to the Polish provisions in this regard, as I mentioned, first I will tell a few words about the provisions of Code of Obligations, where these transplants are more visible. Under the Code of Obligation and in both tort and contract regime, the liability is for both intentional acts or omissions and for negligence. However, due care is defined only in contract regimes, which at the time was a source of controversy. However, it's not the main topic of this presentation, so maybe I will skip it for now. And as we can see, the Article 240 introduced actually two standards of due care. The first one being the care required in proper conduct, and the second one being care required in a particular legal relation. And the second one sets the higher requirements, as it requires to also take into account the inherent features of specific legal relation. For example, okay, and also we have in this code we had particular provisions with regard to, for example, to the responsibility of a custodian or unpaid contractor, just like in a Swiss code. So we can see transplants from German and Swiss codifications, as in both of these legal orders. Negligence equals to the failure to exercise due care, and then the standard is depersonalized. And as in BGB, the basic standard is situated in the general part of the law on obligations. However, as in Switzerland, there is a plurality of standards introduced by the code, which was the fundamental flaw of this regulation, as it was making it both unclear and less flexible, as it's like divided legal relations into certain groups. Okay, so now let's go to current Polish law provisions. At first sight, these provisions may seem similar. However, in fact, here we have only one standard of due care instead of two, and its due care generally required in relations of certain kind. Paragraph 2 doesn't introduce like a higher, better standard of care. It only requires to take into account specific competence or knowledge associated with professional conduct. And this provision is, as I will talk about in a minute, with the conduct of a doctor regarding medical cases. And I would like to add that it's the only standard of due care in current Polish civil code. We can say that we also have the personalized standard situated in the general part of law on obligations. Just as in BGB, we have a distinction to objective dueness and subjective care into these two components of due care. Also, maybe it's just a subjective assumption, I don't know, but we can see clear similarities in the wording regarding BGB and current Polish provisions with regard to due care. However, different than in previous Code of Obligations and then in Swiss provisions, the standard here is uniform, which makes the regulation not only clear but also flexible, as it's as I mentioned before, doesn't distinguish specific groups of legal relations, and what allows for the ad casum analysis of the behavior of the legal entity. Okay, so in the last part of this presentation, I will tell a few words about the influence of such standard on medical cases. This general standard from civil code applies also to medical damages cases, which is further emphasized in Article 8 of the Patients' Rights Act. What's important is how this standard regarding medical cases is reconstructed by courts and legal bodies. As to the rule, it is reconstructed through principles. So through the analysis of the subjective and objective components of due care. So the court has to determine if sufficient level of consciousness was kept in the specific case, and if the doctor complied with praxeological principles of conduct. And I think that such a way of reconstructing the standard is coherent with the personalized model taken from both Switzerland and Germany. However, what's interesting is that there are some medical cases where such a reconstruction is impossible, and it is where manual or perceptual skills are of the most importance. In such cases, courts in Polish case law often refer to the figurative model of a good doctor, which seems to be the aberration of German and Swiss concept of due care, the personalized one. However, I think that apart from the fact that this is the personalized standard, like it's possible, but it's very hard to some extent, it's possible to apply it to such cases. Apart from it, the model of due care in Polish civil code responds to the contemporary challenges of to the due care model, also in medical cases, as first of all, it's flexible, and second, it's allows to, it's coherent with the need for the certainty of law, which is very important if we take into account the challenges that, for example, telemedicine, clinical trials, the development of clinical trials, and new therapeutic technologies made us face. So that's it. Thank you.
Now the floor is yours. Comments, questions? Yes, go ahead.
Okay. Okay. Thank you for your presentation. I wrote one question. Do you think it is possible to reconstitute a due care standard when it comes to the situation in which the activity requires precise skills, taken into account maybe some basic rules, standards, not the personalized standards? I hope it's clear question.
Yes, I get it. As I mentioned, when we have when we want to reconstruct the standards by the rules, we have to take into account the subjective component of care and objective component of illness, and if we we encounter the case where perceptual skills are of the most importance, for example, with radiology, in the most recent cases, from for example, like past 10 years, we can find cases where courts try to reconstruct some basic standards of illness, even if in such cases, and base their judgments on it. For example, when you when the doctor encounters a photo, a radiological photo, he has to go through it like zigzagging, and it's the praxeological rules for radiologists. So the courts nowadays try to find such even basic standards to be further judgments to be coherent with the rule of assertive law. Now it goes more into this direction than by basing in on this figurative model, as it doesn't protect, for example, doctors to sufficient extent.
More questions? Well, I would have a comment. Since when I was listening, you mentioned many standards, lack of definitions, etc. I'm sorry that you did not introduce at least one or two cases The case law would be fine to illustrate what you have explained for us. It's just a suggestion. I'm not criticizing, but I'm curious to learn the Polish case law.
Well, maybe that could be added for the final version of the paper.
Yes.
Well, if possible, why not?
Yeah, I think that's because of the time frame.
Yeah.
I didn't want to focus only on it, and it takes time.
But you have just mentioned probably some of the cases, so you can include them in the text.
That's for sure.
That will be fine.
Yeah. Thanks.
No more questions, then thank you. Natalia, and our last intervener for this session is Piotr Romaniuk from the University of Warsaw Faculty of Law and Administration. The title of his intervention is Evolution of American Competition Law and its Impact on European Jurisprudence, a Historical Analysis from Judge Brandeis to the Chicago School. The floor is yours.
Yeah, thank you. But not least. First, I'll draw the role of the evolution of the competition law in the US, how it started. And then I'll show you the beginning of the competition law in Europe and the discussion between the European and American approach. And as the final part of the presentation, I'll show you the cross points of these legal orders nowadays. So first, let me provide you with a brief description of how the competition law came to existence in the US. It has been known as the antitrust law. Its main reason was to counteract against the trusts. It was formally created by the Sherman Act in the 1890s, aiming to ban cartels and agreements restricting free trade. And to give you the picture, let me quickly read you two key sections of this act. Section 1, every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among the several states or within foreign nations is declared to be illegal. Every person who shall make any contract or engage in any combination or conspiracy hereby declared to be illegal shall be deemed guilty of a felony. And section 2, every person who shall monopolize or attempt to monopolize or combine or conspire with any other person or persons to monopolize any part of the trade or commerce among the several states or with foreign nations shall be deemed guilty of a felony. As you may hear, the provisions of the Sherman Act are not very much precise, and American courts quickly began struggling with its broad and vague language. It was expressly stated in the Standard Oil case in 1911, when the Supreme Court affirmed that trial court's verdict and ruled that Standard Oil's high market share was proof of its monopoly power, ordering it to break itself into 34 separate companies. But the court also held that the Sherman Act's language outlawing every trade restraint actually only banned unreasonable restraints on trade. And Congress reacted in 1914 by passing two new laws, the Clayton Act and the Federal Trade Commission Act, which the first act outlawed using mergers and acquisitions to achieve monopolies and created an antitrust law exemption for collective bargaining, and the Federal Trade Commission Act was to set an independent body, agency that has the jurisdiction with the Justice Department over federal civil antitrust enforcement and has the power to prohibit unfair methods of competition. Despite the passage of these acts, the US antitrust enforcement was not very aggressive between the mid-1910s and 1930s. The court had a largely tolerant attitude toward collusion and cooperation between competitors. One prominent example was the 1918 decision, Chicago Board of Trade against the United States, in which the court ruled that the Chicago Board of Trade rule banning commodity brokers from buying or selling grain forwards after the close of business at 2 p.m. each day at any price other than the day's closing price did not violate the Sherman Act, though it started to change with both the pro-competitive approach for economy of Franklin Delano Roosevelt, believing that the free competition is a key to recovery from the Great Depression, and judgments led by a Supreme Court Judge Louis Brandeis, who believed in a strict structuralist rules that focus on market structures and their level of concentration. The structuralist approach, commenced by the Judge Brandeis, gave birth to a Harvard Law School of Competition Law, which flourished after the Second World War. Judges gave little credence to defendants' companies' attempts to justify their conduct using economic efficiencies, even when they were supported by economic data and analysis. It assumes that the market behavior of enterprises results from the structure of market, which in turn affects market performance. According to this assumption, markets with entrepreneurs with significant market shares and characterized by barriers to entry and low efficiency, this structure also encouraged companies to engage in anti-competitive practices. The economists representing this approach argued that limiting the market power of companies should be a fundamental task of competition law. For the Harvard School, competition was not an economic model, but a goal to which the market should aspire. They argued that market power is a threat to the market, and therefore any merger of entrepreneurs or agreements between them that enable them to gain significant market power should be prohibited by law, regardless of whether they lead to benefit for consumers. The application of this view developed by this school had a significant impact on the activities of antitrust authorities in this time. And that was until the Chicago School of Law became a significant party to the economic debate. The structuralist interpretation of US antitrust law began losing favor in the early 70s in the face of a harsh criticism by economists and scholars from the University of Chicago, not only Chicago, but mostly. Scholars from the Chicago School had long advocated for reducing price regulation and limiting barriers to entry. In line with the liberal understanding of the economy, they argued that as a result of strict antitrust policies, many practices were outlawed, and it increased the efficiency of the economy, which translated into consumer welfare. They also argued that the market power of a company is a short-term phenomenon, that the market regulates itself. Consequently, they saw no need for the state to interfere in the market so strongly at the time. In its view, strict regulations only disturbed natural market mechanisms, thereby worsening the situation of both the country's economy and the consumers. The Chicago School economic analysis led to the famous 1978 US Supreme Court ruling, which oriented the understanding of the Sherman Act in favor of increasing business efficiency, thereby limiting the use of antitrust regulation. Therefore, from the mid-1970s onward, judges' acceptance of their ideas grew, inter alia due to the growing competition from European and East Asian nations, as the pursuit of economic growth is the sole goal of this school, which at the same time assumes it is beneficial to consumers by contributing to their welfare. But what happened in that time in Europe? To understand it, it's relevant to first get back to the end of Second World War, and even a little bit earlier. Outside the US, views on competition law have developed also in Germany in the 1930s at the University of Freiburg, which came to be known as ordoliberalism. According to this concept, in order to achieve economic growth and stability in the economy, an economic order based on competition must be observed. The task of state was to create the conditions for the economy to function, including ensuring the functioning of the competition mechanism. A smoothly functioning economy, in turn, was to provide benefits to society through equal distribution of the benefits derived from them. For the Freiburg School, the goal of competition was to protect the individual economic freedom of each enterprise from excessive market power of other market participants or the state. Such a state was to be achieved by creating a system in which the interest of the state and market participants would be balanced. Competition law, in turn, was to protect the mechanism of competition, make it realistic, and ensure the realization of economic freedom in the market, even at the expense of a short-term increased economic efficiency. According to the Freiburg School, competition was threatened by monopolies, which without state intervention could engage in behavior that harms other participants. Aside from it, in Europe, there was also the Austrian school, though it did not have so much influence on the competition law. There, stemming inter alia from the Freiburg school, competition law began to develop in Europe, mainly under the pressure from the United States. After the war, the interventionism dominated in the west of the old continent, which, under the influence flowing from across the Atlantic, slowly gave way to a liberal view of the economy. However, the Freiburg school, popular especially in Germany, stood in contrast to Chicago, in contrast to their understanding of the pillars of liberalism. But aside from the plainly economic debate, it is worth to note that the European competition law cannot be analyzed in isolation from the development of European integration. The establishment of the European Coal and Steel Community, and a few years later, the European Economic Community. In their light, the antitrust law was to be one of the elements of European integration, being at the same time a guarantee of protection of competition of the markets of individual countries. It was to encourage investment, deepen economic integration, and reduce antagonism between war-torn nations. To achieve that goal, the Treaty of Paris created a common market, which aimed to bring about economic growth, employment, and a higher standard of living in the member countries. It was stated especially in the Articles 4, 5, and 65. The prohibition on abuse of dominant position was formulated in Article 66.7 of the Paris Treaty. The treaty did not specify what the dominant position consisted of specifically, indicated only that it allowed for the protection of the dominant by effective competition in a substantial part of the common market. In addition, the Paris Treaty also contained provisions on merger control, making the approval of a concentration involving the territory of a member state subject to the approval of the high authority. Since the Treaty of Paris, due to the establishment of the European Union and the broad expansion of its border, the axiology of European competition law has undergone some transformations. From once basic premise of the EU competition law, the promotion of European integration, have grown three objectives that have been pursued with varying intensity. It was the pursuit of the maximum realization of the internal market, the achievement of a state of optimal efficiency, and kind of accessory to these first two tasks, the protection of consumer interest. But now let's get back on the other side of the ocean and see how does the axiology look now in the US. The original Harvard-Chicago split focused on large substantive economic issues, in particular, the degree of correlation between market concentration and market power, whether to use a per se standard for vertical restraints, whether a firm could leverage market power in one product market to obtain market power in another, and the ability or lack of firms to engage in anti-competitive predatory pricing. The modern debate between these schools centers less on what types of conduct are potentially anti-competitive than on how to decide when conduct is anti-competitive. It is often difficult to determine with precision whether conduct procedures durable harm no competition. To sum it all up, what conclusions can we draw from the way how the competition law orders have evolved on both sides of the ocean? I will use two examples, the US and EU approaches to the competition law in the examples of the consumer protection and the abuse of the dominance position. In both fields, we can observe that stemming from the ordoliberal roots, the EU approach is a way more strict toward the big companies, especially the big tech companies. And thus European Commission treats both topics more serious than Federal Trade Commission. We can observe it especially in the way that both these bodies handle the big tech issues, with the EU passing Digital Market Act and Digital Services Act to oversight the big tech companies. And in the same time, we can see the case law of European Union handling the big tech companies, starting in 2008 with Microsoft and with Intel a year later, then 3 times against Google in 2016, 17, and 19, against Facebook in 2023, and Amazon in 2022, ended up in a settlement. And recently, Apple punished with a fine valuing around 1.8 billion euro. The scope of FTC doings look rather poor on the EU background, although we have to admit that it is possible to observe a shift in its approach to the big tech. FTC has punished Facebook with the $5 billion fine in 2019. Based on the example of the approach to the big tech companies, we can try to pass a conclusion that while through the last century, the Europe was influenced by the US approach to competition law and had to respond it with its own ways, nowadays the EU is a leader pointing out the directions and goals of the competition law, while the United States try to catch up and respond to the European ideas on how to handle the challenges to competition law, like the one with big tech companies. And thank you for your attention. I'm open to questions, though the time is off, I guess.
Thank you, Piotr. Questions, comments? Yes, of course. Go ahead.
Is it working? Oh, right. Okay, so thank you for an interesting presentation, Piotr. And I have a question. Can we still observe the influence of the Chicago School in the US Supreme Court judgments today?
Thank you for the question. Yeah, we can observe it, kind of, although like nowadays scholars call the main idea of the US Supreme Court like the post-Chicago School. So it stems from the Chicago School. It stems from the efficiency as a key point of competition law, but it also took some points on the way, like not the structuralist approach, but the school uses more economic models like game theory, contestable market theory, transaction cost theory, or competitor price increase theory. And this post-Chicago School is open to some regulations into the market, though it stems from Chicago School. But on the other hand, it's worth to note that we can observe a movement called New Brandeism that refers to Judge Brandeis in the 1930s, and it refers to more strict approach, but it seems not so relevant as the post-Chicago School. Thank you.
Okay, that answers my question. Thank you.
More questions, comments? If there are none, we shall close the session.
Thanks once again to all the participants.
Thank you.
So since we're a little behind schedule due to the technical problems that we've had, let's make the coffee break a really short one. So 5 minutes. The non-Serbian speaking people are free. They have a long break until the lunch break. They have an hour. But so in 5 minutes, we continue with our first Serbian session for today. It's a short one, only 3 papers. And then those of you who won't be listening to that, come back at 2 o'clock for lunch here in the club. See you soon.